Welcome back on the AM show. It's time now for us to talk about some legal matters. Now, in a letter dated 30th of June 2024, the Chief Justice, Gertrude Torkornoo, her ladyship, wrote a letter to the President recommending some 5 justices to be added to the Supreme Court, and it's come under some controversy. The National Democratic Congress has a stand. They're accusing the NPP of packing the Supreme Court for their own intentions. And some NPP members, the majority caucus yesterday, led by Apenyo Makin, was defending that the Chief Justice has done no wrong. But this morning, I'll be joined by some guests from the legal and party places to understand what's really going on and what the controversy is and what's the way forward is. But this morning, right now with me is Martin Kpebu, private legal practitioner. Martin, thank you for joining the conversation.
Good morning, sweetie. Give me 1 minute. I'm trying to pack here.
Okay.
And then.
All right. So we will also be joined by Godwin Eduji Tamaklo, and he's legal and communications team member of the National Democratic Congress, and Xavier Kuje, the PRO for Ghana Bar Association. And in the course of the conversation, they will join us. But Martin, I don't know if you've been able to pack yet. I'm sure you've been following this development story with keen interest. What do you make of the situation? On the back of, first, the recommendation, the President writing to the AG for his advice, the AG's response, the NDC's stand on the matter, and the NPP's defense of the Chief Justice's actions. What do you make of it all?
All of them have been involved in a very illegal conduct. Very illegal from the...
Illegal?
All the actors. Yeah, Chief Justice to President, President to the Attorney General, Godfrey Dami. No, we cannot allow such illegal conduct to continue. It's wrong because the Constitution is very clear on the face of it. Article 144, Clause 2 makes it clear that the Chief Justice, if a Chief Justice can nominate, but it should go to the Judicial Council. Go to the Judicial Council. The Chief Justice cannot write directly to the President. No, that's not the law. So it's surprising that the President also gave it succor by asking the Attorney General for his input, etc. Well, it's not surprising. You know, President Kpebu is a champion of illegal constitutional conduct. So for me, I'm not in the least surprised. That's his stock in trade. He has turned our Constitution on his head several times. So it's not surprising that he's once again involved in such illegal conduct. Listen, the Supreme Court made it very clear in the case of GBA and Nena Megache versus the Attorney General that in cases like that, 3 persons or 3 different parties can nominate. That is that the Chief Justice can nominate persons to become Supreme Court justices or a person to become a Supreme Court justice. The Attorney General can nominate, and the Ghana Bar Association too can nominate. But all of these nominations must go to the Judicial Council. So that is the body that will then vet them, screen them, etc. Upon which those who are successful, there will be a recommendation made to the President for their appointment. So the Chief Justice couldn't have legally written to President Kpebu to kickstart such a process. We all make mistakes, so maybe they should just bring an apology and then we can move on. But there's no way the Chief Justice could have written to the President to kickstart that process. No. You see, and besides, so that's one angle. So by Article 144, Clause 2, and also by the decision in the GBA and Nene Amegache versus Attorney General, 20th July 2016. They are wrong. That's very wrong. Then we go to the second point, right? The second point is that by law, it is not hard law, but we also have what we call convention. No constitution can possibly write everything under this FQA nation. So some of the rules evolve by convention, like the way by convention in Ghana, the vice president is made in charge of the economic management team. It's not stated in the constitution, but we've accepted that that is a convention. So in the same way, by convention, we've said historically that we don't go above 14, or some people say 15 Supreme Court justices. We don't go beyond that. And
Martin,
that is what...
Is it possible that, just because you're saying that some of these rules are not written in the Constitution, but, they evolve by convention, is it possible that the Chief Justice has the mandate to actually recommend these judges, but it's not a hard law, like you say? Is that a possibility? And she's still operating within her mandate, but it's just not a hard law.
No, she's not operating within her mandate. Let's repeat. What the case is called GBN and Amegachi versus Attorney General. What it shows is that she can nominate, but it should go to the Judicial Council. The Judicial Council is an independent body also set up. So she's also part of it. Other Supreme Court justices, they have not just Supreme Court justices, there is a representative of the Superior Court justices, there is a representative of the lower courts. The president has 4 representative people he appoints onto that body, deans of faculties of law, some,
right.
etc. So it's a body that has that constitutional charge. So the case is saying our law is that Article 144 Clause 2, that send the nomination, the interpretation given by the Supreme Court in that case of Article 144 Clause 2 is that send the nominations to that body. So, sweetie, that body would then vet the candidates and do all the other necessary things. Then they write to the president. It's not just vetting. It also means that as a council, they will sit down and look at the propriety of the nomination in the first place. Oh, are there vacancies, etc.? Or will there be vacancies so soon? In the near future. So let's start today. So it's that body that has to collectively take a decision. So when one man hijacks the process and writes to the president, we can't say the Chief Justice was within mandate. No, we all make mistakes. It's a mistake. So we're going to the second point that I'm developing, which is that this case, at this time that you're trying to bring in more Supreme Court justices, it will lead to a case of midnight judges. Midnight. When we say a midnight judge, that's a judge who is appointed at the time that a president is about to exit. No, we don't do that. We don't allow it in our body politic. We are learning from the United States. They had the case of what we call Marbury versus Madison. It's a case that all law students are compelled to read. So every lawyer knows about that case. That is a case in which the second president of the United States in 1801, John Adams, when he was about leaving office, he appointed some judges. Unfortunately for them, because he was just leaving, some of the justices did not receive the appointment letters. So the next president took over, Thomas Jefferson. Then one of the judges or the appointed one, called Marbury. So Marbury then sued Madison. Madison was the Secretary of State under Thomas Jefferson, the third president. Now, come on, give me my appointment letter. So the court went into it and said, no, the appointment letter will not be given. But we got some other great rules out of it, but that's not for discussion today. So, but the political fallout from it, it created so much embarrassment from the government. So since then, in governance, every government tries to avoid midnight judges. You don't make appointments very close to the time you are exiting because something could go wrong and the process will not be finished. So take, for example, Parliament is going to rise at the end of this month. So if you had continued the process, Parliament is going on recess. They are going to campaign, etc. When are you going to call them to come back, etc.? All those things. No, so much expense. We're already bleeding.
Okay.
So you look at it. So the timing is bad. Then the third point is that, and very, very critical, we are back to the convention I raised earlier. So we have said that by law, we don't go beyond 14. Some say it is 15 because when you read the GBA case, some are saying that Atuguba did not add the Chief Justice. So if we add, when you read that Supreme Court decision, they say that we don't go beyond 15 justices, and that's our convention, and that is the law. When we say convention, something we've done over a long period and we've all accepted, it's as good as law. So if we've put the number at 15, and we now want to go to 20, sweetie, the point I can't overemphasize is that let there be a national debate. Let there be a national discussion. It should not rest with the Chief Justice and the President alone. No.
Okay, Martin, before I move on, we have Sylvia Kuji on the line with us. But before I move on from you, Apenyo Markin's argument, and I want to quote what he said. He says that some people are saying that the Chief Justice does not have such a mandate to do so. We disagree, and we would say that per Article 125, Clause 4 of the Constitution, there are some inherent powers provided for in this provision that allow the Chief Justice, as a chief executive and head of the judiciary, to make such proposals. And the Chief Justice's argument is that they are burdened with cases. We've seen that over nearly 600 cases that have been stalled because of the number of justices that currently sit at the Supreme Court. What do you make of that? Before I move on to Xavier.
Yeah, sweetie, let me repeat that last time. Apenyo got it completely wrong. Who says the Chief Justice cannot nominate? In this interview, I've already stated at least 3 times that she can nominate. But the law is that when you nominate, send your letter to the Judicial Council, not to President Kufuor.
All right.
Send the letter to the Judicial Council. The Chief Justice sent the letter to the wrong place. So Apenyo is completely off. That is not the provision to quote. They are saying it's 144 Clause 2. It says that the president will make the appointment based on the recommendation of the Judicial Council. And the GBA case emphasizes it.
All right. Xavier, thanks for joining the program. I'm sure you've been following the conversation to this point. What's your interpretation of the constitutional provisions regarding the appointment of Supreme Court judges? And you are PRO for the Ghana Bar Association. So give us a sense of your thoughts.
Good morning, and thank you for the opportunity. Yeah, the Constitution is clear. When it comes to nominations of or appointment of Supreme Court justices, there are 3 bodies that make nominations: the Ghana Bar Association, the Office of the Chief Justice of the Judiciary, and the Office of the Attorney General. These bodies make the nominations and submit the list to the Judicial Council. The Judicial Council now vets and then settle on certain things that all of sent to the president based on the available data. Then the advisor sends on that. But advice the president find the president can decide that all the I am not.
Xavier, I think your line was breaking. I didn't hear you clearly. Can you take that again? Yes.
I was saying nominations are made the Ghana,
right,
the Office of Attorney General, the Judiciary for the Office of Chief Justice. And that means that the justice cannot just say the word is that those is that the judiciary now, based on that bill and would advise the president on to appoint, which means that even at the level, there can be dropped. And when the chief justice, because just an non-biased president can decide not to appoint body of that, that means that he cannot say no. You have to depend the judicial for the whole country again. So that is what.
Okay, Xavier, we are struggling to hear you, so we'd have to reconnect with you. We'll drop the call and then reconnect with you. But let me get back to Martin. Martin, you missed out a point. I was saying that the Chief Justice's defense for this irregular procedure to nominate or recommend judges to the president is because she says they are overburdened with cases at the Supreme Court. You didn't respond to that. What do you make of that?
Oh, yes, sweetie. There's the workload. There's a lot of backload, okay, of cases, right?
Right.
But that doesn't justify an illegal conduct. So let's not mix them.
Is it? You keep using the word illegal. Is it really illegal, or is it just a procedural breach in in this recommendation? Because the president is not binded to go by her recommendations, is he?
Oh, it's very illegal, very, very illegal. Look, it's a very serious matter. It's only because, we are still a democracy, we are looking for a transitional democracy. We've not quite gotten it, we are not quite there yet. We're a transitional democracy, that's why. Otherwise, this is a very serious case because, this is a convention that has been there for long. A Chief Justice never writes the president like that. So for this thing to happen like that, it's a very big matter. But because we're a transitional democracy, we are all learning, we are all making mistakes. So let's just leave it and then, move on. But it's a serious matter because you see, now with this list, there's a lot of, some undercurrents because some even very senior judges would also not be happy about the list because once this list has come out and some people have been cited, very senior judges to those in the list here, there are so many undercurrents that we don't want to go on talking about this on air. So it's not a very simple matter at all. It's very serious, but like I said, we are a transitional democracy. We are all still learning. About 30 odd years, right?
Right.
Yes, 1992 to now, a few years after 30 years. So we are learning. Even the big democracies, they make mistakes. So let's take it that we all have made a mistake and we can correct it. Because that's how come in our profession, we always tell you that we are all learning, right? So mistakes happen, and once it has happened, let's look at how we can point at it. But you see that it's caused a lot of disaffection and a lot of embarrassment to all of us. Because especially in the context of the president who is known to always want to retard our democracy. So when you write such a letter to the president, they are like, hey, this man already, he doesn't want this country to move forward in terms of democracy. You remember how he torpedoed the appointment of the MMDCs, right? So President Kpebu has a track record, how he hounded Domlevo out of office. We went to the Supreme Court, and by the time the case was done, Domlevo had been effectively put out of office because of retirement, etc. Right? So the point is that it's a very serious matter, but because we are all learning and we are making mistakes, it's fine. We just will gloss over it and move. Right. There's a lot of undercurrents.
Okay, so does this then feed into the NDC's allegations that the NPP is intentionally, deliberately packing the Supreme Court for their own ulterior motive?
Well, that one is a little far afield. That one, let's leave that kind of physiology for the politicians. I'm an activist and a lawyer, so I can't directly go into that side. That one there to be pure politics. That I'm constrained. I have to use what the evidence and normal rules of analysis. But that particular question of packing the courts and the rest, I can't go into that part of the conversation. But like I've said, I'm sure I've made all the points. And so, yeah.
So what about the issue of timing then? You were saying something about midnight judges and the timing is wrong because the courts will actually take a break soon and all that. Do you think that the Chief Justices, on the back of her launching of that Leading Justice initiative, do you think it's just a way of clearing all this backlog before a new term begins?
The Leading Justice initiative, yes, the Chief Justice did well on it. But this particular one is specifically about the problem in the Supreme Court. That's this backlog of cases.
All right.
So, like we've said, we are even about to go on a legal vacation. Yesterday, Xavier Kuje made that point on PM Express. We are about to go on legal vacation. So the whole of August and September and the first week of October, we are on legal vacation. So even if we were to do all these things, eventually, as I've said, Parliament is also even rising. We are going into an election, etc. The timing is very bad.
Okay.
We can have the conversation in January. Let's make this point strongly. Let's have a national debate in January that we are moving from our convention of 15 judges to 20. Is there merit or no merit? So the Chief Justice will come and make the case for the backlog. I'm also suffering the backlog, right? But because justice emanates from the people, let the people weigh in. Let the ordinary citizens weigh in. Article 125 plus 1 of the Constitution says justice emanates from the people. So why your law is that we don't exceed 15 justices of the Supreme Court, and now we want to go to 20, please, it shouldn't be the president and the Chief Justice alone having that conversation. Let's have a national debate. Let people come in, let people also share their opinions. And then when we finish, you see that once the case is made, and let me not...
All right, you hold for me, Martin. Xavier joins us back online. Xavier, you were trying to make a point about your interpretation of all of this. Please go ahead.
I was saying that just as Martin said, there are 3 nominating bodies when it comes to appointments to the bench.
Yeah.
The Ghana Bar, the office, the teacher, and this the teacher, and office of that. And it happens that nominated by names the teacher. The teacher is now fed these pillars and big fight on that point. But that combined with the president, we just ordered this submitted, except that it doesn't have power to prepare. So you have to prepare the other for process to start a role. So that is what he can say some of it and not just speak. So that's about it. But I must say that there is violence. There's nothing wrong. I think that proves what the problem is.
Xavier, I struggled to hear you there, but help me make sense of it. So Martin is saying that this is straight down illegal, but the Chief Justice is saying that it's because of the backlog of cases that need to be cleared. That's why this procedure was, this route was taken to recommend judges. What is the position of the Ghana Bar Association in all of this?
Yes, as I started, can you hear me now?
Let's try again. Maybe it will get clearer as you go. Go ahead.
Can you hear me?
Yes, this is better.
Okay. Yes, what I was saying is that the request per se, I do not see anything wrong with it.
Okay.
Because, mind you, the Constitution gives us a minimum. 9 justices with a Chief Justice making a thing constitutes a Supreme Court.
Yes.
But what it means is that as a people, as a nation, going forward, we can review it upwards. That is why we have replacing with a certain conventional number of justices. Today, we have about 15 of them. So if there's a need for us to increase that number, all we need to do is to do some discussions with appropriate bodies and stakeholders and see if there's a need for that. I must say that the brief sent to the president was sent to us for our opinion. And the request was supported by settling statistics regarding the workload at the Supreme Court. Based on that, we agreed with the Chief Justice in principle that there might be the need for the numbers to be increased from 15 to the 20 as is requested. But because it's a conventional number we've been working with, and we're not ready to do a constitutional amendment, bodies such as Parliament and the Council of State should be consulted on this matter. That was the position we took. We even went ahead to suggest that to help all this, the Supreme Court must be automated so that recordings can be taken just as they are going on. Because all this, the absence of all this accounts for the backlog. Because judges will have to do everything almost in longhand. Then we also went ahead to say that research assistants should be found for them, libraries should be built for them, and all that. So it's not as if, for me, as I said, the request in principle, there's nothing wrong with it.
Okay. I read this morning about Sami Jemfi saying that the Chief Justice must resign because of this, and if it's illegal, what do you think should be the next course of action in correcting this procedural breach?
Sami. This is just an irregularity. we all make mistakes, just as Martin said. She should have sent the letter. Just there's nothing wrong with it. The point is get it directly for the country. But if you have like system, so the judiciary they wouldn't have it. They wouldn't have it. So they wouldn't do that after contest. You can see the other board also suggests this, and then the process go on. So just that this went direct to the president. That's the better competition in the process. So for me, it's just a mistake that she's made, and that is irregular.
All right, so
a warrant stepping out of office.
So can a Chief Justice be pardoned for a mistake like this?
Why not? Why not? For me, there's nothing wrong with it. And I must also say that as a people, we shouldn't hold it against the various names that we've seen. They are competent people in their own right who are qualified to be appointed to the Supreme Court. So if the time comes for them to be for appointments to be made and their names come up, nobody should against them because we don't have evidence that they are part of the suggestion to send the name directly to the press.
But this is the Chief Justice, Xavier. Are you saying that she didn't know that what she was doing was irregular? I mean, so if you're going to pardon her, we just want to understand on what basis we're pardoning her. She didn't know that she was supposed to go a certain way and then she did that. And so, it was a mistake. We pardon her. But on what basis would you be pardoning the Chief Justice for a breach like this? An irregularity, like you say, like this?
My sister, we all make mistakes. There's a particular meal that as a woman, I believe you cook every time. Sometimes you may forget the ingredients that you may have them in the family. So I don't think that we should be worried. It's not upon them. We have not yet with it. Is that you are than the requirement. If you have to defend it, is that it was wrong. What was right. So what that you should leave off on this. There are grounds that not to
I'm still struggling to hear you, but this is my final bit to you, and then we can wrap up. I was reading on Arthur Kobina Kennedy's Justice in Chaos for Ghana, and she says that it looks as if our judicial system cannot take a break, right in the middle of the case, which the Attorney General has seen coaching a witness in the absence of the defendant's lawyer, etc. And now we are seeing this happening now. So, I mean, as spokesperson for the Ghana Bar Association, how can the public be assured that the judiciary remains independent and impartial? Because those watching the plots and how it unfolds in all these instances must be concerned. How are we assured that our judicial system is impartial?
I think let's make an admission first that the judicial service or the judiciary is made up of human beings. They may have their flaws. But I think that we should continue to have confidence in our institutions. Because the institutions are there. It is those manning them that we have problems with. And they will not remain there forever. Any other person who is qualified and competent can man them one day. That if we begin to badmouth them now, what do we have people one day can maybe judge better than what's happening now? So for me, be patient. Mistakes that these are just troubling times for the judiciary, but get over it. So it's not that it's intentional that one another one. No, it's not like. So I will urge and everybody, of course, that they need to have confidence in each other for that matter.
Xavier Kuje is PRO for Ghana Bar Association. Thank you so much for joining us. But I still have Martin on the line with me. Martin, what do you make of the submission from Xavier? Do you think the Chief Justice should be pardoned because this is a mere slip?
Considering that, yes, it's a mistake and we all make mistakes, maybe she can render an apology and then let's see how the citizens react. Yes, it's something. We all make mistakes. So she can bring out an apology. Oh, people of Ghana, I'm sorry. I didn't intend to upset the constitutional arrangement and all that. And then once that is done, it's good. We should be able to move on. Yes.
Based on our history and even the way that this has been plunged into some sort of political sides, do you see that happening? Do you see the Chief Justice apologizing for this and then going through the proper channel to recommend these judges?
Well, going through the proper channel to recommend these judges, not now. As you said, not this year. We can't even have that recommendation done now. Let's have the conversation first, because we are changing the law. So if you are changing the law, get the buy-in of the people first. Then as to whether to render an apology or not, well, I don't have a crystal ball. Let's go into it. Let's see what she says. It's an evolving democracy, but you see how the Kenyan president conceded. He conceded neatly when the Gen Z people did the demonstration. You see, the president said, I concede, and then he made a lot of reforms. So the Chief Justice can learn from it, because it will help a lot. It will help to bring people on board. At least it will help to bring the NDC back on board, because now the NDC are saying no. And you know, they even went ahead to say they would trigger impeachment proceedings against her. Yesterday on PM Express, Sami James stated it, that they would trigger impeachment proceedings against the Chief Justice. So it tells you that they are not happy. So it will help that the Chief Justice reaches out to citizens and said, look, because you see, we've all now lost a lot of time and effort debating this matter. So an apology is not out of place at all.
All right.
I think it's the least.
Okay, thank you. Eduji Tamaklo is legal and communications team member of the NDC, and he joins us now. Eduji, your party is a director for legal and communications for the NDC. Eduji, your party has accused the NDC of intentionally packing the Supreme Court. And the PRO for Ghana Bar Association is saying this is just a mistake. How do you reconcile your allegation with what they're saying?
You see, first of all, the office of the Chief Justice is one of the most important offices of this republic. It's an office that has the benefit of sound legal advice from the creme de la creme of lawyers in this country. So it cannot just be a conversation about mistake. It cannot just be. These are very serious matters. The appointment of justices of the Supreme Court is regulated by Article 1442 of the 1996 Constitution. Right. And the constitutional provision, as far as Article 1442 is concerned, the CJ has no role to play. At best, is to chair the council, the Judicial Council. It ends there, and to advise the president appropriately. What she has done has never happened. Has never happened. And you see, I say this. You interviewing me now, if you are desirous of buying, say, a land, and you want to do due diligence, you go to your lawyer. Lawyer, advise me on how to buy the land so that it will be litigation free. If it turns out that the lawyer advising you is the owner of the land, how would you take that advice? So when the framers of the Constitution were putting this Constitution together, they anticipated all these scenarios and said, let the president, and in fact the word you say, shall. So the president does the appointment. He comes to you to advise him, so that your advice will appear fair, impartial, among others. Now, if you are the one now proposing things, what will be the nature of your advice on the very name that you have proposed? On the very name that you have proposed.
Right.
It's a very serious matter.
What about the
I just hope that we learn useful lessons from what happened, so that it doesn't repeat itself again. The role of the Supreme Court, and remember, even for presidential elections, the Supreme Court has exclusive original jurisdiction in the matter.
So
the 5 ladies these are judges that have practiced before. They are excellent judges. But the process, if the process is flawed, what can come out of it?
Are you saying it's not pardonable? And will you still go ahead with your impeachment threats? How would you even go about it?
As somebody was saying, tomorrow is pregnant. Let's leave tomorrow to decide on that matter.
What is your reaction to the argument that there's no constitutional backing, or there is an argument that the number of judiciary justices is not capped? That is the argument that the majority caucus is making.
If you look at the response of the NDC to the question that first of all, there's no capping on how many justices of Court of Appeal, Supreme Court, right? But we have said, if there's a plan to move it beyond the current number, we should build a certain critical level of consensus. Two is the timing. The Chief Justice said in her confidential memo to the presidency justifying it, he says that the workload. Now, question: if you appoint these justices today, July is almost through. Parliament will go on recess. Parliament comes back say October. October, November, December. Are these judges are the ones going to clear the backlog of cases?
Mm-hmm.
So,
all right.
Like the Ghana Association said, the timing is just not right beyond the procedural flaws.
Thank you so much, Godwin Eduji Tamaklo. I'll come back to you, but let me go to Martin. Martin, we're wrapping up. What are your final words on this matter? And then I'll come to Godwin, and then we'll go.
Okay, yeah, so sweetie, my final thoughts are that this case, this faux pas brings to fore the urgent need for constitutional amendment. Okay? Yes, we've been crying about the need for a new constitution. This our constitution is so bad. It is retarding our progress. The constitution 1992 has to be seriously overhauled. The Chief Justice herself, at her vetting, indicated that she doesn't want a constitution in which the president has a role in the discipline of judges. That's what she said, though. So that's the removal of judges. I'm sure the way she doesn't want the president to be involved in the removal of judges, she'll have a soft thought for a suggestion that the president should equally not be involved in the appointment of judges. Listen, this is weakening our democracy. You see what a bad leader can do? You see what a bad leader can do? Now we have a bad leader. You see how we are retrogressing. So that's a big lesson to us that let's overhaul this constitution. No president should be appointing chief justices and Supreme Court justices. No, no way. You see what a bad leader can do to Ghana, and we are suffering for 8 years. We've been retarded. You see, I mentioned earlier the appointment of the MMGCs, but now we have made progress. When Kpebu thought that he had lost the debate, then he canceled the whole thing. Personal aggrandizement. Look at other parts of the constitution. Appointing ministers from parliament. It is also retarding our progress. So we need to make all these constitutional amendments to make Ghana a better place. So right now, our constitution is our biggest problem. It's retarding our progress. Let's get on with the constitutional review quickly so that we can have a new constitution.
Thank you so much, Martin Kpebu, private legal practitioner, for sharing your thoughts with us this morning. Mr. Tamaklo, talk to me about the Chief Justice's defense, about the backlog of cases and the need for more justices, and then you can wrap up with your final words.
Yes, let me just wrap up. I've already pointed out the appointment process includes going to Parliament. We are almost getting to the middle of July.
When are these names going to come to Parliament? Parliament is now going to allow for members from the general public on this house. Now they are going to go to the appointment. Parliament puts the exam. When this what is just to eradicate or clear backlog for the December election. So clear, we must leave this market for 2025 going.
Right.
So, my learned senior raised the critical point of a constitutional amendment to see if we can place ceiling in the United States of America Constitution, quite older than us. It doesn't place a ceiling on the number of Supreme Court judges in the U.S. But they have convention involved the nine. As I speak to you, there are growing calls among Democrats that President Biden must go beyond the nine and appoint more as to balance the conversation in the U.S. But the way President Kpebu has conducted himself will be extremely difficult to restrain any other president from keeping to the 50. It will be extremely difficult.
All right. Thank you so much, Godwin Edujitamaklo, Director, Legal Affairs of the NDC. And that brings us to the end of this belt of conversations on the AM show. We'll be back with more. Stay with us.